Is everybody here ready? Oh, are you ready to just do my spiel? Are they ready over at the jail? It's showing that the system is on, but that the speakers are off. Do I have to turn those speakers on? Ah, okay.
Good morning, Judge.
Good morning. You ready over there? Perfect.
We sure are.
Okay, great. Good morning, folks. I'm Jane Fishman. I'm the county court judge presiding this morning. You're here for a first appearance hearing. There's 3 things we're going to do this morning. The first purpose of the hearing is to determine if there's probable cause for your arrest. That means whether there are reasonable grounds to believe a crime may have been committed and you're the person who committed it. If I find there's no probable cause for your arrest, one of 2 things may happen. I may give the state up to 24 hours to produce additional facts to show probable cause, or I may direct you to be released. If you're released for lack of probable cause, it does not mean the case is over. It only means that you'll be released from custody. If the state wants to proceed against you on these charges, it has the right to do so. The second purpose is to determine whether you should have a lawyer appointed to represent you. You have a right to counsel. If you have your own attorney and you want him or her present, you should let me know that, and I'll direct the bailiff to attempt to reach the counsel. If we cannot reach your attorney, the proceeding will have to be delayed. If you want to have the public defender appointed to represent you, just let us know that. I'll appoint a public defender to represent you if you qualify for the services of the public defender. You must completely fill out an application for indigency, which will be provided to you, and the clerk of court will determine if you meet the statutory criteria for having a public defender appointed to represent you. You will be charged $50 for the processing of the application, which is due 7 days from the date of the application. Please understand that the services of the public defender are not free. If you eventually enter a plea of guilty or no contest, or if you are eventually found guilty of the offense with which you're charged, then a judgment may be entered against you for the reasonable value of the public defender's services. The third purpose is to determine what type of pretrial release, if any, should be set in your case. Now, each of you has the right to remain silent under the Fifth Amendment to the United States Constitution. You're not required to say anything, and anything you say may be used against you. You also have the right to communicate with counsel, family, or friends, and if necessary, you'll be provided with reasonable means to do that. If this session of first appearances goes like many others, you'll likely see that some cases will be resolved. We'll determine what kind of release is appropriate, whether a pretrial release program on certain conditions or a bond under certain other conditions, or your own recognizance. For some of you, I may set a bond, and the factors significant in setting a bond are whether you failed to appear in court in the past, whether you were on probation at the time of the alleged new offense, and whether you have other pending cases, that is, other cases for which you still have to appear in court. Other factors are how long you've lived in Broward County, your family ties to the community, your employment history, financial resources, the nature of the charges against you, and the penalties you may be facing if you're convicted. For some of you in minor cases, the state may offer you an opportunity to end your case by entering a plea of guilty to a sentence of time served or a short jail sentence. You need to understand that the state has the burden of proving each and every element of any charge they've lodged against you beyond and to the exclusion of every reasonable doubt. If you feel that the state cannot prove it, or that you are not guilty, you should not enter a plea of guilty or no contest. You do need to know, though, if you plead to certain offenses, there are certain things you need to understand. For driving while your license is suspended with knowledge, for instance, if you plead to 3 of those within a 5-year period. The Department of Highway Safety and Motor Vehicles is going to revoke your driver's license as a habitual traffic offender for a period of 5 years. If you plead guilty and are convicted of petty theft, and you have 2 prior convictions for petty theft, the state of Florida may choose to charge a third or subsequent as felony petty theft. And if you are convicted of possession of cannabis, you will lose your driver's license for a period of 1 year. That happens automatically by statute. You can make an application to the Department of Highway Safety and Motor Vehicles for a special permit, but that's between you and the department. And if you have 4 or more of certain separate misdemeanor convictions within 1 year, the law may require you to be sentenced to 6 months in jail. And if you enter a plea of guilty or no contest to any offense and you've previously been convicted of a sexually motivated offense, or if you are pleading to a sexually motivated offense, this plea may subject you to involuntary civil commitment under the Jimmy Rice Act. As I say, if this session of first appearances goes like most, you will see a number of people pleading guilty to time served or to short jail sentences. If you don't think you're guilty, or if you don't think the state can prove you guilty beyond a reasonable doubt, you should not enter a guilty plea here today. But I will not be entertaining any pleas to DUI cases, to batteries, or to felonies. Okay, I've been here since early morning and reviewed the probable cause affidavit, so just come to the podium when your name is called.
Judge,
Yes,
I've been advised here by the deputies, they would like to address a certain gentleman out of order.
okay.
The person is Tavarius Turner. He is on page 8 of your docket. Mr. Turner, come on up. Judge is a friend of the court. He's right. And as a friend of the court, I had an opportunity to speak with Mr. Turner. He's here on a capias from here, Broward County, and an out-of-county hold, which is Dade County. He wishes to ask the court if you would consider resolving count 1 for time served, so then Dade County could come and pick him up. He has a $7,500 bond on count 2.
Yeah, okay, it's a misdemeanor. I do recall seeing it. Let me see if I can just find it, because I don't have a docket here, so tell me his name one more time.
It's Turner, Judge.
Tavarius Turner on page 8.
Thank you.
Just before the halfway point of the docket, I would think.
I got him. Okay, yeah. There's the misdemeanor capias is for driving, I think, while license suspended, operating without a valid driver's license. Okay, and use is okay, the driver's license, yes, is revoked, but just failure to pay. Yeah. Okay, and so you want to resolve that Broward misdemeanor for operating without a valid license with a plea of
Yes,
no
ma'am.
contest this morning? Okay, I'm going to accept that plea of no contest. I'm going to adjudicate you guilty, sentence you to time served. There's court costs of $293. You're going to have 90 days from your release from custody to get those paid, and your driver's license is revoked. So once you resolve your Dade County hold, you may want to get a copy of that to address it and see if you can't fix that up, okay? Good luck to you, sir.
Thank you, Judge.
Sure, okay. Kaylee Wood?
Paul Ryan, Judge.
Kelly Wood? Yeah? Anybody have Kaylee Wood? Huh. Nobody?
I think that's her, but I guess they can't hear.
Is that her? And they just can't hear us?
They can't use. But I think they're about to remedy that situation.
Okay. It's them. They have to turn something on. Everything I have, I think, is on. Okay. There we go. Okay, Ms. Wood, good morning. You're here this morning on an out-of-state felony hold. I do find probable cause for the charges. There's no bond. Good luck to you, ma'am.
Thank you.
Okay. Salim Willis.
Judge, for Mr. Willis, on the finding, can you please correct that to reflect case number 171802?
171A2. Okay. Okay, Mr. Willis, good morning. You're here this morning on an out-of-state hold, a felony hold from Sumter County. I do find probable cause for the charges. Good luck to you, sir. I'll move a little closer. Ryan Sternko?
He's here present, Judge Amain.
Yes, good morning, sir. You're here this morning on 2 out-of-state holds, felony holds, as to which no bond is available. I do find probable cause. Good luck to you, sir. Corey Butler.
Mr. Butler's here. Amain.
Yeah, good morning, Mr. Butler. You're here on counts 2, 3, 4, and 5. Out-of-state holds on felony cases. Okay, and the other has been taken care of. I do find probable cause. Good luck to you, sir. Oh. I'm gonna put another book up there. Okay, we'll see if that works better. Kimberly Curran.
Ms. Coran is here present, Amain. She's the coaching judge.
Good morning, ma'am. Ma'am, you're here this morning charged with disorderly intoxication. Bond is set in the amount of $25. I do find probable cause. Did you want to resolve this with a plea of no contest this morning?
No.
No? Okay, great. Good luck to you, ma'am. Yes.
Judge, respectfully, in speaking with Coran, she informed me that this is the first time she's been arrested. She's 46 years old. At this time, her husband's deceased. She just started employment at the location where this occurred. She was the hotel manager. Unfortunately, she has no funds to bond out. What I would be asking for, considering this is a nonviolent offense, I believe second-degree misdemeanor, would you consider an ROR if the state can verify this is her first offense? And she advised me she's a registered voter.
Okay, is it the first?
I'm not showing any criminal history.
You're not showing any criminal history? Okay, that's fine. I'll release her on her own recognizance. Ma'am, I hope you understand, ma'am, that means that you're going to get another court date and you have to appear in court. And if you fail to, a capias is going to issue for your arrest. You understand that?
Yes, Your Honor.
Good luck to you, ma'am.
Thank you,
Thank
Judge.
you.
No, maybe that's. Chelsea Jones.
North Broward, Your Honor.
I would make an argument in this particular case as
ahead.
to the heroin being in the joint possession of both Miss Jones and the driver. I'd ask the court to consider that factor in either not finding probable cause or in addressing Miss Jones's bond.
Okay. State, did you want to respond?
Well, is it a PC argument?
Yes.
It was right under her leg.
Yes, but it's not her car. And
Didn't right up-
I'm going to find probable cause. Do you want to be heard as to bond?
Judge, Miss Jones has been living here all of her life. Unfortunately, she does not have a stable residence at this time. She was staying in a halfway house. Right now, she's going through detox. I'd ask the court to reduce her bond to $500 so that when she gets through that process, she can contact somebody to come and get her out.
Okay. Any objection?
Well, Your Honor, just so the court's aware, I'm showing she just got off probation for possession of coke. She was placed on 6 months probation for possession of cocaine January 30th of this year, so it
Clear-
looks like she
Go ahead.
she got off probation about a week ago.
Clearly an indication, Your Honor, that Miss Jones is capable of completing probation successfully.
Okay. I'm going to reduce the bond to $750. Good luck to you, ma'am. I do find probable cause. I don't know what that was, but. Rayanne Knight?
North Broward again, Your Honor.
Okay. Good morning, Ms. Knight. You're here this morning charged with.
morning.
Yes. you're here this morning charged with possession of a controlled substance without a prescription. I do find probable cause. Your bond is set in the amount of $1,000. Good luck to you, ma'am.
Your Honor, Ms. Knight indicated to me that she's been living here all of her life. She has provided me with the phone number of her husband, who I'll contact later, but I don't know that he's going to be able to come up with $1,000 for bond.
I'm showing an at-large address.
I believe that's correct, Judge, but I think that once she gets together with her husband, she'll be able to find someplace to stay. She said her only prior, if the state can confirm this, is a drug arrest from 2010, which would be an indication that she's been out of trouble for quite some time.
State want to be heard?
She had a resisting without violence 09 in Broward. She had a battery that she went through a diversion program on. Seen arrested in 2012 on an out-of-county hold for resisting law enforcement, possession of cocaine. I don't know if she has anything else out of county. She's not on my list. Out-of-county priors.
Okay, all right. I do find probable cause. I'm going to leave the bond at $1,000. Good luck to you, ma'am.
Come back inside cell 1, please.
Trina Ross Mahaber. Okay, okay, okay.
Ms. Ross Mahavier, is your present, Judge?
Okay, and ma'am, you are here this morning charged with grand theft. Bond is set in the amount of $1,000, and there's I believe it's a driving while license suspended. Let me check. Yeah, driving while license suspended capias for failing to appear at arraignment, as which bond is set in the amount of $500. I do find probable cause for the charges. Yeah, go ahead.
And speaking of Ms. Ross Mahabir, in reference to count 1, it's $1,000. She advised me that she can't afford it. She's 47 years old. Right now, she's going through the process of applying through disability, so she hasn't received her first paycheck yet. She lives in Fort Lauderdale, been residing in the same apartment for the past six months, so she does have a valid address. What I would be asking you to, I believe she was interviewed by pretrial. I would ask you to consider placing her on pretrial for count 1. So therefore, whatever funds she does have or anything like that, she could use in reference to count 2.
Your Honor, I don't believe Ms. Ross Mahabir is a candidate for pretrial, considering she's already here on a failure to appear. She was arrested last year on another failure to appear.
Judge, we can't hear the prosecutor.
Okay, she's here. What the state said was she's here on a failure to appear, and there was another failure to appear.
Second arrest last year for failure to appear. She's violated probation in the past. She's been Florida State Prison in the past. Uttering forged instrument, priors, theft, grand theft, uttering forged instrument, fraudulently applying for a driver's license. Grand theft, forgery.
Okay.
She did advise me she has priors, but I believe they're dated.
Yeah, she's got no driving while license suspended priors that would cause her to be habitualized if she wants to resolve the driving while license suspended charge this morning.
Oh, let me ask her. Thank you, Judge.
Okay.
Judge, she would be would want to accept the court's offer as far as resolving count 2.
Okay, all right. On count 2, I'm going to withhold adjudication. She'll have court costs and costs of prosecution that total $293, and they will be due in 180 days from her release from jail. On the grand theft, pretrial didn't. You interviewed her and weren't recommending.
Yes, Your Honor, she has a very extensive history.
Okay, all right, I'll reduce that bond to $750. Okay, good luck to you, ma'am. Don't drive till you get your driver's license reinstated. Katrina Hambrick?
North Broward.
North Broward.
Yes, I got it.
Yes, sir. Thank you.
Okay, Good morning, Ms. Hambrick. You're here this morning charged with possession of cocaine. I do find probable cause for the charges. Your bond is set in the amount of $1,000. Good luck to you,
Your Honor,
ma'am.
I'm going to be asking the court to consider pretrial release for Ms. Hambrick. She's been here in Florida for 7 years. She has a job that she's had for the last several months working here downtown. She has been living in the same residence for the last 3 years, and she indicates to me that she has no priors and 2 dogs that she needs to take care of. And if it's true she
Did
has no
pretrial
priors...
interview her?
Yes, Your Honor, her friend stated that they're posting bond and we were unable to verify her address.
Okay, what's the address? What's the permanent address?
Me?
Yeah,
Yes.
you.
1100 Southwest 22nd Terrace, Fort Lauderdale.
Okay, well, the booking report shows that you've been there 0 months.
No,
That's
I've
the
been there
address you
3
couldn't,
years.
is that the address you could not validate?
It was on my Florida ID. I should have known it was my prior address on my Florida ID.
That's fine.
And state there's no priors or prior failures to
I know she has no Broward priors. I don't know if she has criminal
Okay.
history elsewhere. I know
Never.
she's-
Okay,
Ma'am.
Yes, Your Honor, that was the address.
that was the address?
Yes.
Okay, all right, I'm going to adopt the recommendation that you be admitted to pretrial release on the conditions that will be imposed to you. You'll need to go to the Office of Pretrial Release before you, before tomorrow morning at 8? Is she gonna go?
Today is possible if she
Today.
gets out in time, or if not, tomorrow morning.
Okay,
And Your Honor, because it's a drug charge, we're requesting a random drug testing
yes,
and a drug evaluation.
yes, random drug testing and evaluation. All at the defendant's expense, right?
Yes, Your Honor.
Okay,
Thank you, Judge.
thank you.
Good to go?
Okay,
Thank you, ma'am.
Joelle Rutgers?
She's here present at main judge. She's declined the services of the public defender.
Okay, all right.
What am I doing?
Good morning, ma'am. Ma'am, you're here this morning charged with touch or strike battery and a count of resisting an officer without violence and one of resisting officer with violence. I do find probable cause for the charges. On the battery, the bond is set in the amount of $1,000. On the resisting an officer with violence, does the state want to be heard as to a bond?
No, Your Honor. Whatever the court feels appropriate in their discretion.
Okay. Okay, on the resisting an officer with violence, the additional bond will be $500.
You know, we just asked it to be in order of no victim contact.
Yeah.
battery charge.
In the event that you post bond, you're to have no contact with the alleged victim. Is it Stephen Desengwe? Yeah, okay. All right, good luck to you, ma'am. Dimia,
Was that on count 3, 500?
yes, count 3. Count 2, there says no charge. Dimiani Maduro.
North Broward, Your Honor. North Broward.
Okay. Okay, Mr. Maduro, you're here this morning charged with loitering or prowling. I do find probable cause for the charges. Your bond is set in the amount of $25. Did you want to resolve this case this morning with a plea of no contest?
What does that mean, Your Honor?
It means you'd be giving up your right to have a trial and to have the state prove your guilt beyond and to the exclusion of every reasonable doubt, and you'd be giving up your right to talk to a lawyer. And I would sentence you now, and you would get out at the end of your sentence without having to post the $25 bond, and the case would be over. If you post the bond, you'll have to come back to court on those charges.
So I'll be going home today if I give up all my rights?
If you give up your rights today or tomorrow.
And the bond is only $25?
That's right. You can post bond and then come back to court and have the state prove your guilt beyond a reasonable doubt, or try to do that, okay? Is that what you want to do? You want to post bond?
No, I don't want to post bond.
Okay. Do you want to resolve the case, or do you want to continue a plea of not guilty and stay in custody until you can post bond?
Continue the plea.
Okay, you want to, so you were
Wait,
going to,
no. I'm so sorry. I want to resolve, Your Honor.
you want to resolve the case this morning with a plea of guilty?
Yes, Your Honor.
Okay. Have you got a lawyer there that you're looking
No.
for advice there?
No, sorry. I just have nerve problems, Your Honor.
Oh, okay. I thought perhaps somebody was advising you out of the, off to the side there. So you want to resolve this case by pleading guilty this morning?
Yes, Your Honor.
Okay, on the loitering or prowling, I'm going to find you guilty. I'm going to sentence you to time served plus one more day. All right, good luck to you, sir.
Thank you.
Moses Gideon.
Excuse me, I need clarification.
Mr. Gideon is here present, Judge
You're
May.
saying
Mr.
two things,
Gideon,
you're saying time served.
come on up.
Plus one more
So
day.
you want him to get out tomorrow?
Yes, tomorrow.
So we could just say 2 days with credit time served.
Okay, 2 days with credit for time served. Okay,
Better give him 1 day.
okay. Sure. Moses Gideon.
He's here present, Judge May.
Okay, good morning, sir. You're here on 4 different misdemeanor capiases. There's 3 from a single case, which was operating without a valid driver's license, possession of cannabis, and operating without a valid DL. Let's see. And possession of paraphernalia. That's one case, and the bonds are $2,000 each. And then there's a $500 bond, I think, for another operating without a valid driver's license. Yeah. Okay.
Judge, and speaking of Mr. Gideon, he did advise me as far as the reason why he was trying to get into, as far as the reason why he missed court, it wasn't willful. I did advise him that that's something he would have to take up before the assigned judge. However, Mr. Gideon does wish to ask the court if he would consider resolving his cases that he has before you today.
Okay.
Counts
Yes.
1 through 3 are in drug court. I would ask that he go before Judge. Counts 1 through 3 are in drug court. I would ask that he go before Judge Zeller before the case are resolved.
Okay. All right. The total of $6,000 bond is what Judge Zeller has?
Yes.
Okay, so he went into drug court. He went into drug court
Did you go into drug court?
with Judge Zeller?
Judge, that's what he just confirmed to me. It was in front of Judge Zeller.
Okay, then let's let the counts 1, 2, and 3 go back to Judge Zeller. And on count 4, which is my case anyway, on the operating without a valid driver's license, I can certainly resolve that one for him if he wants to do that. And on the operating without a valid driver's license, that would be adjudication and time served and court costs and cost of prosecution. That would be due 180 days from his release from jail.
Judge, if I
Okay,
could have a second to speak to him?
yeah.
Thank you.
Yes, oh, right, of course it does. I know.
Thank you, Your Honor.
Let's see. Does the public defender in the jail know that he'll see Judge Zeller on August 9th?
The court wants you to know that Mr. Gideon will see Judge Zeller on August 9th.
Judge, and speaking of Mr. Gideon, what he's asking me, Judge, is, I know those 3 cases are in drug court and potentially, I'm assuming that this case, if he successfully completes it, they could be dropped. That's what I was advising Mr. Gideon of. One of the benefits of not resolving it today but he still wishes for me to ask Your Honor if you would consider resolving 1, 2, 3 as well as count 4.
Okay, I don't want to do that because I don't know where he is along in the process, but he can talk to Judge Zeller about it. His date is August 9th at 1:45. Okay, good luck to you, sir.
And Your Honor, we would just ask that Your Honor, the case on count 4 be transferred to drug court also, just to keep everything together.
No, I just resolved count
Oh,
4.
I thought you said
No, he didn't resolve count
he
4.
didn't want.
Oh, he doesn't want to resolve count 4?
Well, if he's going to go to drug court, then
Right,
We'll
okay,
get him over.
fine, that's fine, that's fine,
Thank you,
okay.
Judge.
Yes, then let's transfer 4 from 30 to drug court.
thank you,
Thank
Judge.
you. Okay. Wixon Pierre?
Mr. Pierre is approaching. He's here at Maine. He wishes to ask Your Honor if you would consider resolving this case.
Yeah. Okay. Okay, good morning, Mr. Pierre. You're here this morning charged with trespass. I do find probable cause. Bond is set in the amount of $25. If you want to, actually, I think it was my case, so. Okay. If you want to resolve that trespass case this morning with a plea of no contest?
Sir.
Yeah. Okay, if you want to resolve it and give up your right to have a trial and I'll adjudicate you guilty and sentence you to time served. Good luck to you, sir. Counsel, what are you here on?
Good morning, Your Honor. On page 7, I have Patrick Shirley.
There has to be court closed, don't they?
Mr. Shirley, come on up. Your turn.
Stephen Eisenband for the record on his behalf.
Okay.
Page 7.
Yeah, he's actually not the next one, but the one right after. Okay, good morning, Mr. Shirley. Your counsel's here at the podium. You're here this morning charged with resisting an officer, obstructing without violence, another count of resisting an officer, obstructing without violence, a traffic capious, as to which no bond is available, and another resisting an officer without violence.
Judge, may I clarify the capias?
Yeah, sure.
Okay, this is not a traffic capias.
No, I see a contempt.
That's correct, before Judge Kaplan. Mr. Shirley retained me about 10 days ago to basically file a motion to set aside that capias and reset the hearing that he missed in order to resolve his matter before Judge Kaplan. I filed that motion along with my appearance on August 2nd. I have copies of both for the court. I do know that the merits of the motion would need to be heard before Judge Kaplan. However, basically, I was wondering what we can do for Mr. Shirley right now, considering part of the reason why the contempt order was issued was because he missed a status on an order to show cause because he missed his batterers intervention program meeting, which he has another one coming up this week. So while I've been working with Judge Kaplan's JA to try to set this down so we can get him back on the straight and
Have you
narrow.
got a hearing date with Judge Kaplan?
We haven't, Your Honor. So
Okay.
that's why I was hoping to have all of this done so we could avoid this today, but unfortunately he was picked up yesterday.
Right. Well, I can, I can resolve the resisting officer without violence with a plea of no contest to time served, and then as soon as you can get in front of Judge Kaplan can lift that capias or not as or do what he sees fit.
I understand. So basically there's no way I could get him out before we see Judge Kaplan, is that correct?
Well, I can't let him out on a no bond capias.
Understood, of course.
you
All
know.
right, so I'll go ahead and guess and
But
set an
I would
emergency
think if
motion.
you were to walk it, well, I don't know upstairs or where he is in this building, but I would think if you would walk it up, you might be able to get that signed and get it all in process.
I do appreciate that, Judge. So, Mr. Shirley, he's at the main jail, yes?
Yeah,
Okay, Mr. Shirley, I'm gonna come see you this afternoon. I'm gonna go walk it up to Judge Kaplan, so I guess,
Okay.
at this time, we're not gonna resolve
You
the
don't
other
wanna
matters,
resolve
just to see if we can, work something out.
okay,
But,
all right.
okay, so, Patrick, I'm gonna come see you as soon as, I can speak to the judge, all right?
Okay, so the resisting the officer is still standing with a $100 bond.
Okay, thank you, Judge.
Okay, good luck. Jamal Conley? Good morning, Mr. Conley. You're here this morning charged with resisting an officer without violence and operating without a valid driver's license and failing to use due care. Okay. As to those charges, I do find probable cause. Your bond is set in the amount of
all three charges?
Well, the failing to use due care is a civil traffic infraction. The operating without a valid driver's license, there's no charge, so there's no bond necessary. And the resisting the officer without violence bond is set in the amount of $100. Good luck to you, sir.
Judge, I'm being advised right now, Mr. Conley is declining the service of public defender.
Thank you. Okay.
Yeah,
Chase Lowe.
I operated without a valid driver's license. I know that, but I ain't resist arrest or none of that.
That's fine. That's fine. You can post your bond and enter a plea of not guilty when the time comes,
Yeah, I'm not
okay?
guilty though.
That's why you're not gonna resolve it this morning. That's fine. Good luck to you, sir.
I'll resolve it then.
Chase,
North Broward, Your Honor, for Chase.
Chase Lowe, okay, and you're here this morning charged on a misdemeanor capias, a petty theft capias. Bond was set in the amount of $250. There, on that capias, there is a status set for August 9th. I do find probable cause. Good luck to you, sir.
All right, thank you.
Davon Johnson.
Mr. Johnson's here present. He did advise me he's going to be posting his bond, Judge.
Okay, Mr. Johnson, you want to go ahead and post bond on the resisting an officer charge?
Yes.
Okay, there's also, there's two other charges that don't require any bond. This one bond is set in the amount of $100. I do find probable cause. Good luck to you, sir. Derek Beach.
Mr. Beach? Oh, Judge, I've been advised Mr. Beach bonded.
Okay, that's good. Richard Chambers.
Mr. Chambers is here present, Judge of Maine.
Yes, sir, you're here this morning charged with trespass. I do find probable cause. Bond is set in the amount of $25. Did you want to post a bond, or did you want to resolve this matter this morning with a plea of no contest?
Your Honor,
I want to resolve it.
my only concern is this appears to be someone's residence. It appears that based on what's being mentioned in the report that there might have been issues in the past. I don't know if this the homeowner might have any issues that really should be presented to they may want to present to a court before the case is resolved.
Okay, it
We
appears,
can't
I
hear
think.
anything Mr. Lunder's saying.
Okay. He said that he's opposing my resolving the case without having heard from the homeowner, the alleged victim, since there was, since this is not the first time that he's been there. Clearly, these two people had a relationship, and he was trying to get to see the child or get property or whatever. So,
Judge, in the alternative, if the court's not comfortable resolving this case today, I'd ask you to consider releasing Mr. Chambers' ROR. This is a nonviolent offense. Monetarily or financially, Mr. Chambers did advise me he cannot afford to post bond. He's actually financially indigent. He is homeless. But he did assure me he has no problem cooperating with the court order as far as no return to that premises while this case is pending. Judge, so therefore we'd be asking you to consider an ROR.
right, okay, Mr. Chambers, it's clear to me from the probable cause affidavit that you knew you weren't supposed to be there. You've got, I guess, some unresolved issues with property there or with the lawful resident of that premises. I'm going to release you on your own recognizance, but you're to have absolutely no contact with that person or return to that address while this case is pending. Do you understand that, sir?
understand.
Okay, if there's property in that location that you believe to be yours that you need, you're gonna need to go to a police station and ask the police to help you with that so that you don't go there. You understand that?
All right.
Okay, good luck to you, sir. Kimbrel Farley.
Mr. Farley is here present, Judge?
Okay, Mr. Farley, you're
Judge,
here.
he declined the service of public defense.
Okay, you're here this morning on a misdemeanor capias in the amount of $1,000 on a charge of, the capias was for failing to appear on a driving while licensed suspended charge out in the West Satellite. If you want to resolve that case this morning, I see you're suspended for failure to pay. Let's make sure that it won't.
Looks like this will be a third, Judge.
Okay. 214, yeah. Okay, this one, Mr. Farley, this one would cause you to be habitualized. So I don't want you to plead to it this morning. But what I'm gonna do is there, are you working? Are you currently working?
Yes.
Okay.
Yes.
I'm gonna reduce the bond on the capias since it's my own capias that I issued, and you're gonna get another date to come back to the West Satellite. If you come back to the West Satellite with your driver's license fully reinstated, the state attorneys there are gonna null pros this case, dismiss it without any record at all, so you won't get habitualized. Okay, so I'm gonna reduce the bond to $100. Don't drive until you get reinstated. I'm also sending you your driving record with your paperwork, so you'll know what has to be cleared. And make sure that you keep us up to date on your address and come to all the court dates that you're ordered to, okay? Good luck to you, sir.
Thank you so much.
Sure. Brian Morrow?
Mr. Morrow's approaching, Judge, is your name?
Yes. Oh, sorry. Okay, Mr. Morrow, you're here this morning charged with DUI and failing to use due care. I do find probable cause for the charges. Bond on the DUI charge is set at $500. The infraction requires no bond. Good luck to you, sir. Oops. The citation fell off. Okay. William Simon.
Mr. Simon's here present, Judge. I mean, this is a municipal ordinance case.
Yes, it is. Good morning, sir. You're here. Oh, good morning.
y'all. No worries. George Odom standing in on behalf of Mr. McLaurin. He's here on page 9, Mr. William Simon. Judge, I'm asking first that the court inquire and declare Mr. Simon indigent so that Mr. McLaurin's law firm may be appointed to his municipal ordinance case.
Okay. Mr. Simon, are you working?
No, ma'am.
Do you have any assets?
No, ma'am.
Okay, I'm going to declare him indigent for the municipal ordinance defense.
Thank you, Your Honor.
Okay.
Judge, I am asking if the court is inclined to resolve with a withhold of adjudication since it is an 893 violation, then I believe Mr. Simon would be open to resolution today.
Okay, are there priors?
Your Honor, I'd have to check. I'm sorry, what is his last name?
Simon.
S-I-M.
William Simon?
Yeah.
Showing, drug paraphernalia out of St. Lucie County from a couple months ago. Looks like prostitution a couple months ago out of St. Lucie County.
Are those convictions?
Showing he had another paraphernalia that he was adjudicated guilty. On the prostitution, he was adjudicated guilty. Also on the other paraphernalia, he had a municipal ordinance paraphernalia that he was adjudicated guilty last year out of Broward.
Okay, all right. It appears he's never had the benefit of a withhold. Yeah, I'm going to go ahead and withhold and impose the municipal ordinance court costs. He'll have 90 days from his release to get those paid. Good luck to you, sir.
Thank you, Your Honor.
Jose Chevalier Garibay?
Judge, I've been advised medical loan.
Hospital.
Oh, okay.
Reset that for tomorrow, Judge.
Okay, I see it was already reset once. I mean, I could find probable cause today and just reset it for bond purposes. I mean, either way.
That's what, Your Honor, that's what the state would request, because it's been 48 hours now. I have no objection, obviously, being brought back for a bond review.
Right, yeah, okay, that's fine. All right, so I am going to find probable cause for the charges, and we can bring them back tomorrow for bond. Okay, thank you. Mark Falugo?
Conti, Your Honor.
Conti, okay. Good morning, sir. So you're here this morning on an additional charge of violation of your felony probation, as to which no bond is available. I do find probable cause. You're going to have a hearing on that VOP on August the 14th. Good luck to you, sir.
Okay, thank you, Your Honor.
You're welcome. Brian Battle? Brian Battle?
Mr. Brown Battle? Mr. Brown Battle, come on up. Judge, he's here present. He declined to serve as public defender.
Okay, all right. Good morning, sir. You're here this morning charged with possession of cannabis over 20 grams and a violation of your felony probation. I do find probable cause for the charges. The possession of cannabis, bond is set in the amount of $1,000. No bond on the probation violation, and you'll have a hearing on the VOP on August the 14th. Good luck to you, sir. Johan Guerin. Garin?
Mr. Giron,
Sorry,
come on up,
Garon.
please. He's here present.
Good morning, sir. You're here this morning charged with possession of cocaine. Bond is set in the amount of $1,000. I do find probable cause for the charges. There's also an infraction that requires no bond. Okay.
Judge,
Yes.
speaking of Mr. Giron, unfortunately, he's been residing in our community for the past 17 years. He's 33 years old. He's financially indigent. He works at a labor pool. He's back and forth between addresses. He was living at a hotel called Universal Palms, but he also has a friend in the community at Fort Lauderdale that he can stay with. There's no way he can come up with $1,000 bond. What we'd be asking you to consider is, considering this is a nonviolent offense, we would be asking you to consider placing Mr. Guerin on standard pretrial.
Well, without a permanent address, I'm not sure that pretrial services wants him.
No, but that's true. I don't think they want anyone without an address, but it's certainly within the court's discretion.
Right, I understand that.
It's a pretrial, and if he doesn't go ahead and check in or anything like that, a warrant's going to be issued for his arrest. So rather than him staying here in custody on a nonviolent offense, that's what I
Okay, I understand your application. State you want to be heard?
Yes, Your Honor. 2013 video voyeurism. He was sentenced to 14 months Florida State Prison. 2010 possession of marijuana. 2008 resisting without violence. 2004 DUI. State would just request that the $1,000 bond be kept in place.
Okay, all right. I'm going to keep that $1,000 bond in place, and I'm going to deny the application for pretrial release. Good luck to you, sir.
Yes, sir.
Bo Kinzer?
Mr. Kinzer is here approaching, Judge, I mean?
Yes. Good morning, sir. You're here this morning charged with possession of heroin. Bond is set at $1,000. There's also a drug paraphernalia charge, which requires no additional bond. I do find probable cause for the charges.
Your Honor.
Yes.
Just to advise the court, Mr. Kinzer is currently on release on a grand theft that has been filed. Just to bring it to the court's attention if you choose to sua sponte revoke his release or not.
Okay. Good luck to you, sir. Martin Goon?
Mr. Mr. Goon is approaching, Judge. He declined the service of public defender.
Okay, good morning, sir. You're here this morning charged with aggravated battery with a deadly weapon and a violation of your felony probation. I do find probable cause for the charges. Did the state want to be heard as to bond on the aggravated battery?
Yes, Your Honor. Noting that he's on probation for aggravated assault against a victim over the age of 65. He's also been convicted twice before in 07 and 06 for aggravated assault. The 06 case, he violated his probation and was sentenced to just under 12 and a half months Florida State Prison based on his violence in the past and the violent nature of this offense. The state would be requesting a bond in the amount of $15,000 and no victim contact.
And did the public, he declined the services of the public defender.
Yes, Your Honor.
Okay, on the aggravated battery, I'm setting bond in the amount of $10,000. There's no bond on the probation violation. You will have a hearing on the VOP on August the 14th. Good luck to you,
Your Honor,
sir.
no victim contact?
Yes, in the event that you post bond, you're to have no contact with the alleged victim. Wayne McMullen.
Mr. McClellan? Mr. President, main judge?
Good morning, sir. You're here this morning charged with possession of burglary tools, burglary of an unoccupied conveyance unarmed, petty theft, possession of Xanax, and possession of amphetamine. I do find probable cause for the charges. As to counts 4 and 5, bond is set at $1,000 each. As to the petty theft, count 3, bond is set in the amount of $25. As to the possession of burglary tools with intent, bond is set at $1,000. Did the state want to be heard, and the public defender want to be heard as to count 2?
Yes, Your Honor. As far as count 2, the state's going to be requesting a $7,500 bond. He has an open felony. If the court elects not to sua sponte revoke his release or bond in that matter, then the state would also be requesting that should he post his bond, he be placed on pretrial release with a GPS monitor. Mr. McMullen is currently on release for fleeing and eluding law enforcement with the DWLS. Additionally, his criminal history includes 2008 robbery by sudden snatching and resisting with violence. He was sentenced to 19 months in Florida State Prison as a habitual offender. 2003, possession of alprazolam and cocaine. He violated his probation. Trespass and loitering, 01. Possession of cocaine, 2000. He's had dealing in stolen property, 97, with the VOP.
Well, we can stick with this century. Okay, anything from the public defender?
Yes, Judge. At this time, what we'd be asking you in reference to count 2 is to impose of a bond of $2,500. I do understand the state's concerns. This is a third-degree felony. Normally, I would be asking for $1,000. That's why I'm suggesting a $2,500 bond. I'd ask you at this time to take no action on the case that he's currently out on. The state could always file a motion, have that matter addressed in front of his assigned judge.
Okay.
He's right.
Okay, on the burglary of an unoccupied conveyance, I'm going to set bond in the amount of $5,000. I'm not going to deal with the other outstanding charge. The state can take care
Your
of
Honor,
that.
as far as the state's request for a GPS, the concern being not only these offenses, but that is.
In the event that he postpones,
Yes.
yes. Okay, that's going to be granted.
So Judge, count 2, you change it into
5,000, yes. And in the event he posts bond, a GPS device. Okay, good luck. Giovanni Castano.
Mr. Castano is here present.
Okay, Mr. Castano, you're here this morning charged with possession of methamphetamine, riding a bike, that's an infraction, requires no bond. And you're here on a misdemeanor capias on a battery charge. Bond on the capias is $1,000. Bond on the possession of meth is set at $1,000. I do find probable cause. Good luck to you, sir.
Your Honor?
Yes.
On count 3, it's a domestic violence capias from an unserved summons. So this is the first time Mr. Castano is appearing before a judge. I would ask if the court would impose a domestic violence no contact order with respect to the alleged victim, whose name is Nicole Spiegel.
Okay, in the event that you post bond, Mr. Castano, you're to have absolutely no contact with the alleged victim, Nicole Spiegel?
Yes, Judge.
Thank you. Okay, good luck.
Judge, one moment, if I can ask Mr. Cassano one question now that I learned it's a TV. Hold on, please. Thank you, Judge. No, nothing
Okay.
more to add.
All right, thank you. Jonathan Rhodes?
Mr. Rose is here, President, declined service of public defender.
Right, good morning, sir. You're here this morning on a violation of your felony probation. No bond is available. I do find probable cause for the charges. There'll be a hearing on the VOP on August 9th. Good luck to you, sir. Christopher Grimes?
He's here, Maine.
Good morning, sir. You're here this morning charged with a violation of your felony probation. No bond is available. I do find probable cause. There'll be a hearing on the violation of probation on August the 15th. Good luck to you, sir.
Thank you. Have a good day.
Jason Burke?
Mr. Burke? Jason Burke?
If we could have one moment on him, Judge, they'll be bringing him up.
Okay. Mario?
He's out and back. Should we put him on brief recall?
Yes, yeah.
Mario Rodriguez?
Mario Rodriguez?
He's here?
Okay, Mr. Rodriguez, you're here this morning charged with carrying a concealed firearm. Bond is set in the amount of $1,000. I do find probable cause. There's additional charges that are infractions or operating without a valid DL, which looks like it's been no charged. I do find probable cause. Good luck to you, sir.
Judge, we have Mr. Burke here present.
Okay, good.
Mr. Burke is
Jason
here
Burke.
present, Judge. He declined the services of public defense.
Okay, good morning, Mr. Burke. You're here this morning charged with battery on an officer and criminal mischief. I do find probable cause for the charges. The bond on the criminal mischief charge is set at $1,000. State, did you want to be heard on the battery charge?
One moment, I'm just checking to see if there's a criminal history.
O come, Emmanuel.
Okay, Mr. Burke, you have a lovely voice, Mr. Burke. We're just checking to see if you have any criminal history charges.
Until the Son of God appears.
Your Honor, I don't see any criminal history. States request a $1,500 bond.
Okay, on the battery charge, I'm setting bond in the amount of $1,500. Your total bond then is $2,500. Good luck to you, sir. Wilfredo Gonzalez?
He's here present, Judge Maine.
Okay. Good morning, Mr. Gonzalez. You're here this morning charged with 2 counts of battery on a police officer, 1 count of assault, bond is set at $100, 1 count of fraud, bond is set at $100, 1 count of unlawful possession of the personal ID of another, bond is set at $100. 1 is possession of a legend drug without a prescription, bond is set in the amount of $25. A criminal mischief charge over $1,000, bond is set at $500. A disorderly conduct, bond is set in the amount of $25. There's there's a resisting an officer with violence. There's a resisting an officer without violence, bond is set at $100. There's a trespass, bond is set at $25. And a misdemeanor capias for failing to appear at arraignment on a charge of failing to register the vehicle, as to which the bond has been set at $250. I do find probable cause for the charges. Does the state wish to be heard on the battery charges and the resisting officer with violence?
Your Honor, on the 2 battery charges, the state's going to be requesting bond in the amount of $2,500 each, $1,000 on the resisting with violence. Mr. Gonzalez' criminal history out of the state of New York, trespass last year. He had assault that was from 2012, Your Honor.
Okay, what does the public defender want?
Judge, in speaking with Mr. Gonzalez, $2,500 bond on count 1 and 2, and then $1,000, I believe, Mr. Lunder said on count 9, is something Mr. Gonzalez is not going to be able to afford. He's a carpenter. He averages about $500 a week on a good week. He's currently living in Fort Lauderdale. He's 32 years old. He has no one that he can call right now that has any access to any sort of monetary funds to help post his bond. What he's trying to do is he's trying to go to school to try and get a better job prospects.
Was he interviewed by pretrial release? No.
What we'd be asking you to consider, Judge, is releasing Mr. Gonzalez on pretrial. If not, in the alternative, we'd be asking you to consider setting a bond on count 1 and count 2 $1,000 each, and on count 9 $500 each. Besides that, we would have 2 additional requests. We'd ask you to sign an order allowing access to his phone contacts so we can potentially try and locate any one of his friends that has any sort of money to bond him out. And 2, we would ask you to sign a photo order so we can photograph Mr. Gonzalez's injuries.
And, Your Honor,
Okay,
He has an extensive record.
thank you.
And I'm just going to advise the court also, he also had another assault out of the state of New York, attempting to cause physical injury. He went to state prison in New York for unlawful possession of firearm and menacing. And he also had a resistance without violence and criminal mischief out of Orlando in 2010.
Okay.
Just for the record, Your Honor, was also, in my recommendation, was also noting the alleged threats that law enforcement heard the defendant making to individuals.
Okay, on count 1, I'm setting bond in the amount of $2,500. Count 2, $1,500. And count 9, $1,000. And I will give him access to his phone so he can call somebody for bond help. He does have a status on August the 21st. Okay, good luck to you, sir. Oh, make sure I sign both pages. Richard Pace.
Mr. Pace, come on up. He's here present, Judge Amin.
Good morning, Mr. Pace. You're here this morning charged with defrauding a financial institution, grand theft, 3 counts of passing a forged or altered bill, and in addition, misdemeanor capias. Let's see, for, open container. I do find probable cause for the charges. Bond is set in the amount of $3,500 on count 1, $1,000 each on counts 2, 3, 4, and 5. And on the misdemeanor capias, bond is set in the amount of $100. Good luck to you, sir. Robert Mosier.
He's here present, Judge Amin.
Yeah, good morning, sir. You're here this morning charged with dealing in stolen property. Bond is set at $3,500. Falsely declaring yourself to be the owner of pawned items. Bond is set at $1,000. Grand theft, under $20,000 but more than $10,000. Bond is set at $1,000. There are 2 misdemeanor capiases where bond is set at $2,500 each. And there's an out-of-county felony hold, which the bond on that is set at $2,000. I do find probable cause for the charges. Good luck to you,
Your
sir.
Honor, the state would request an order of no victim contact.
No victim. And the alleged victim is,
Mr. Mayor, could you have him come back, please?
yeah,
I can get that information for the court.
I
we
think it's
can-
here.
Here, Mr. Lunder.
Maybe
when you-
blacked out in
Is it Graciela Benita?
here.
In the event that you postpone, Mr. Mosier, you'd have absolutely no contact with the alleged victim, Graciela
No,
Benita.
that's the officer.
oh.
It's Faith Leonard, Your Honor.
Faith, what's the last name?
Leonard.
Leonard. Okay, absolutely no contact with Faith Leonard. Good luck to you, sir. Matthew Marshall.
Mr. Marshall?
Good morning, Mr. Marshall. You're here this morning charged with a violation of your felony probation. No bond is available. I do find probable cause. There'll be a hearing on the VOP on August the 9th. Good luck to you, sir. Joey Pierre Toussaint.
I've been advised he bonded, Judge.
Okay. Lansberth Blackwood.
Mr. Blackwood?
Sir, you're here this morning charged with aggravated battery with a deadly weapon and resisting an officer without violence. I do find probable cause for the charge. On the aggravated battery, did the state want to be heard, Esteban?
Yes, Your Honor. Mr. Blackwood has a criminal history, 2013, burglary of a dwelling and grand theft. He violated probation. A moment. Based on his criminal history and the level of alleged violence in this case, Your Honor, state would be requesting a $10,000 bond on count 1, no victim contact.
Okay, and did the public defender want to be heard?
Judge, in speaking with Mr. Blackwood, he's 22 years old. He's been residing in our community for the past 6 years. He is employed. He works for Fleet Car Wash. He's been working there for the past 2 months. He gets paid weekly. He gets paid about $180 per week. He lives in West Park with his sister. He's been residing in the same residence for the past 4 years. The only person that he's going to be able to call to post his bond is his girlfriend, who babysits. Therefore, what I'd be asking you to consider, Judge, is setting a bond of $2,500. From what Mr. Blackwood advised, I believe he has one prior serious offense, and that's why the defense will be making the request of $2,500.
Okay, on the aggravated battery, I'm going to set bond in the amount of $7,500. In the event that you post bond, sir, you're to have absolutely no contact with Diego Oti, the alleged victim. Good luck to you, sir.
Yes, Judge.
Jeremy Holly.
Come on up, Mr. Hollis.
Okay. Good morning, sir. You're here this morning charged with grand theft. Bond is set in the amount of $1,000. I do find probable cause for the charges. Good luck to you, sir.
Judge, Mr. Holly's advised me that he's never been arrested. If that's the case, if the state can confirm that, and this is a nonviolent offense, would you consider an R1 on Mr. Holly's behalf?
Is that the case? No priors?
He has juvenile priors, and it's nonviolent, but it's not a victimless offense.
Okay. And what about pretrial? Did you interview him for pretrial release?
Your Honor, yes, I've tried contacting his family members. We were unable to verify his information, so it'll be at your discretion.
Okay. What I'm going to do is I'm going to leave the bond for now, but pretrial release is trying to contact his family. If
Yes, impossible.
and I will admit him to pretrial release on those conditions once they validate his family.
Okay, so it'll be
So it'd be $1,000 pretrial release pending verification.
Exactly.
Yes, thank you.
Okay. Thank you, Judge.
Thank you. Good luck. Albert Wilson.
Mr. Wilson's here present, Judge Amain.
All right, good morning, Mr. Wilson. You're here this morning charged with battery on an officer and resisting an officer with violence. As to these charges, I do find probable cause. Did the state want to be heard as to bond?
Your Honor, state would just be requesting a $1,500 bond.
Okay. Public defender want to be heard?
Yes, Judge. In speaking with Mr. Wilson, he's 47 years old. He works at Jason's Prime. He's a cook. He just started working there, so he hasn't gotten his first paycheck. He was told he's making about $13 an hour. He lives in Fort Lauderdale with his girlfriend. He has no money, no property. Judge, unfortunately, when he was arrested without his wallet. So therefore, he has no funds available to him. we'd be asking you to consider releasing Mr. Wilson on pretrial, or in the alternative, we'd be asking you to consider setting a bond of $500 on count one, $500 on count two.
Okay, did pretrial consider?
Yes, Your Honor, he had no information for us to contact anyone.
Oh,
To
okay,
verify his information.
okay. Mr. Wilson didn't provide any names for anybody at pretrial release to contact for pretrial release. Okay, on the battery on an officer, I'm going to set bond in the amount of $750. On the resisting an officer, $250. And if he provides information to pretrial and they verify it, he can go on pretrial. So it's a total of $1,000 pending verification of PTU.
Judge, two other requests. Would you sign an order allowing the Office of Public Defender to photograph Mr. Wilson's injuries?
Yes.
And number two, an order allowing him access to his phone contact.
I thought you said he, oh, yeah, okay, sure. That's fine. Good luck. Victor Menendez.
North Broward.
Mr. Menendez.
He's at North Broward, Your Honor. He's right here.
He's right here, okay. And
Yeah, he can see. I don't know if you can just see his head. He's in a wheelchair right
yes,
now. Yes, he's looking right at you.
Yeah, I can see. Mr. Menendez, you're here this morning charged with possession of drug paraphernalia. Bond is set at $100. Tampering with physical evidence. Bond is set at $1,000. And driving while your license is suspended with knowledge. Let's see, third or subsequent. Let's see if you are at felony level. Yeah, actually they are. He is from 2015 and 2016. Okay, I do find probable cause for the charges. Good luck to you, sir.
Go and roll yourself out.
Jacario Coleman.
I've been advised he bonded, Judge.
Okay. And James Render.
Mr. Render's here present at Maine.
Okay. Okay, good morning, Mr. Render. You're here this morning charged with 3 violations of community control felony. No bond is available as to any of them. I do find probable cause. There'll be a hearing on August 9th. Good luck to you, sir.
Good luck to you.
Robin Crisione.
North Broward.
Yes, Your Honor.
Okay, Mr. Crisione, you're here this morning charged with 42 counts of possession of Xanax, and count 43 is a violation of your probation, as to which no bond is available.
Of course.
I'm a little confused as to why it's 42 counts. I don't know if you can help me.
I wouldn't discuss the facts of your case at this point in time, Robin.
No problem, sir. I was just curious.
So we're going to send somebody up to take a look at you, sign you up for the public defender's office, okay?
That sounds good to me, sir.
I think that's the number of pills. Does,
Your Honor, and obviously, I have no objection to the court RORing counts 2 through 42. The only thing I would ask, Your Honor, in setting a bond on count 1 is to take into consideration the amount of pills that he allegedly
yeah,
was in possession
okay,
of.
okay. And does the public defender want to be heard?
Well, Your Honor, he has a no bond hold. He's going to have to go in front of his division judge. Would be fine. The court RORing him and all the other charges that the state mentioned.
Yeah, I know.
Okay. Well, on the on count 1 of the possession of Xanax, I'll set bond in the amount of $1,500. And as to the remaining counts, the remaining counts of Xanax, the other 41, I'll ROR them.
Thank you, Judge.
Okay, all right.
Wait, can you explain that to me? How that? So I have.
So you're on a no bond hold anyway, so you aren't going anywhere.
I knew that, but so why am I ROR'd on all the other Xanax, but I get a $15,000 bond for one Xanax? I'm confused.
1,500 for the first one, and ROR'd because I'm a good-hearted human being,
I
okay?
understand. Do you have a court date for my VOP?
Nope. Good luck to
Nope.
you, sir.
Thank you.
Justin Steinberg?
Been
Justin,
advised medical loan, Judge?
And Your Honor, like the other defendant we had earlier, and this has been reset since the 3rd.
okay,
I'm gonna ask if a PC determination could be made.
yeah.
Frankly, I have no objection. I remember we discussed this with Judge Zeller on Friday. It looks like there was a total of 53 notes, counterfeiting notes that were found. I don't believe that they can be, or they shouldn't be, split up into 5 groups of 10. So I have no objection to the court finding PC on count 1 and no PC on 2 through 5.
Okay, that's one way to do it. All right. Yeah, all right. In the defendant's absence, having read the probable cause affidavit, I'm going to find probable causes to count 1, and no probable cause as to the others.
The only thing I would ask, Your Honor,
Yes, sir.
is because since it's no PC, he'll have to be ROR'd on those counts.
Right.
I do believe, though, that what I would ask the court to do is to take in.
But he still has to come back for bond on count 1.
He does. What I would ask the court to do is to take into consideration, I'm going to be asking for a bond increase based on the sheer number of counterfeiting and the amount that was allegedly counterfeited, with no objection to it being without prejudice and that it can be reviewed and brought back.
I would object to that. If his bond is going to be raised, he should be here.
He should be here.
Yeah,
Yeah.
but Your Honor, the problem, here's the problem.
And you're worried that he's going to bond out when he
Why
feels
should he
better.
get the benefit of not having aggravating factors addressed because he's,
Well, then we can leave all of it for later. I mean, the PC is there. It's just a
Then-
question of,
well, see, okay, then, Your Honor, then I would ask, well,
okay, so I'm going to find probable causes to counts 1 to 5, and we'll bring them back. We'll bring them back for bond purposes, and we can always ROR them at that point.
thank you,
So
Judge.
we're leaving the bond.
We leave them on there with 1,000 each, right?
Yeah.
Thank you.
I mean, he's got to be here for, got an opportunity to talk to a lawyer. Okay. All right. I bet this is Aurelio Daniels.
It sure is, Judge.
Okay, good morning, sir. Okay, and he's back because,
Perfection on a couple of the counts.
right,
I don't have anything new. You can be ROR on these counts.
okay, all right. Since the state's come up with nothing new and he was previously found no probable cause on counts 2 and 6, he'll be ROR'd on those counts. Okay, good luck to you, sir.
Thank you, Judge. I'll explain it to you.
Judge, it was just 2 and 6 or 2 through 6? What was
2 and 6.
2 and 6. The other day, the judge found probable cause on 1, 3, 4, 5, 7.
Okay, thank you.
Okay, thank you. Okay. That concludes the morning docket. Relatively painless, yeah, let's see, system off.